Just try to get to this
All right, we're here. Okay, everyone. Sorry about the delay. We had to do some alternative internet arrangements here so that we could bring the live stream to you. And I've got some questions coming in, so thanks everyone for your patience, and we will try to get to them as quickly as we can. I know a lot of people are away because of Canada Day and have sort of decided to make this a short week. So for those of you who decided to join us, thank you very much. I'll introduce myself. For those of you who don't know me, my name is Bradley Chaplick. I'm a condominium lawyer at Horlick, Levitt, Lella. And we've been doing these live streams for like 15 weeks now, every week, and we really enjoy doing them. We love the chance to connect with all of you. And so you guys can ask us your questions, and we're definitely going to talk about masks because that's a big issue right now. And I know a lot of condominium corporations want to know whether they are required to have mandatory mask policies and what that would mean. So before we get to that, we'll just answer some of the questions here. The first one from Michelle. If there is a vacancy on the board of directors with 4 remaining board members, so let's say that you've got an original board of 5 and you have 1 vacancy, can 2 of them appoint another director? At the meeting where 1 director is absent and 1 abstains, the agenda did not disclose that they would be discussing on appointing a new director. Okay, so there's lots going on here. So the first thing we would want to remember is that on a board of 5, quorum is 3. So you need to have 3 directors at the meeting. And so Michelle is indicating that you have 4 directors, and of those 4, 1 is not present. So you have 3 directors. So because you have 3 directors, you have a validly constituted meeting. And that's really important. And then at that meeting of 3, you could pass a vote by 2 to 1, or even 1 to 0 in a sense, right? So it is possible that you could have an appointment in which you have 4 directors on the board, 3 attend the meeting, and then you vote 2 to 1 to appoint somebody, and that would be valid appointment. But another issue that Michelle, you've raised here in your question is that it was not disclosed on the agenda of the board meeting that a director would be appointed. And in my view, I think that's actually a problem because for the director who was absent, that director could have been present and voted on that issue had the proper notice been given. So in my view, the appointment of a director is something that needs to be disclosed in the notice of the board meeting in order to have a proper vote on that issue. And if the director who was absent were to object on that basis, in my view, that would be a valid objection. So I hope that answers your question, Michelle. Lots of interesting procedural points there to unpack. So moving on to our next question from Bruna. Hi, Bradley. Real estate agent wants to stage a suite for sale and wants to resume regular showings. Can we restrict this or should we allow? So the first thing I'll mention is that there is still an emergency order in place for all of Ontario when it comes to, oh, you're welcome, Michelle, when it comes to open houses. So the realtor is not permitted to have an open house, and that is where you have the property available for not like a scheduled appointment, but really anyone from the public can drop in. And in addition to that, most condominium corporations' rules already restrict or don't allow open houses. So there would be no open houses. With respect to staging the unit, I don't have a problem with that. And then when you say regular showings, I think it would be appropriate and proper for a condominium corporation to have a policy in effect for real estate showings. And so that policy could reasonably include things as restricting the number of people who attend a particular showing, requiring the wearing of masks, and all sorts of other safety precautions that you would implement that would be true of all real estate showings. There would also be concerns if the unit that's being shown is occupied by a tenant, which is probably not true in your case because you've mentioned that they're staging it. So taking all of that into consideration, I think it's reasonable to put restrictions in place. It shouldn't be a excuse me. It shouldn't be a free-for-all, and people should be respectful of the fact that unnecessary showings should not be allowed. So people should be seriously interested purchasers and not just coming around to kick tires on the unit. I don't think you would have that anyways, but I hope that answers your question. Reasonable restrictions are definitely permitted, and that would be things like number of people and that kind of thing. So hope that answers your question, Bruna. And while we wait for a few more questions to come in, I think we should talk about masks. So as many, if not all of you would know, the City of Toronto, Toronto City Council unanimously passed a bylaw on June 30th, which is to take effect on Tuesday, July 7th, making the wearing of masks mandatory in enclosed public spaces. And the question that is on my mind, or was, and is probably on your mind, is whether that includes residential condominium buildings, and also perhaps whether it includes commercial condominium buildings. So to answer the question about commercial, it would apply. It applies for any enclosed commercial establishment. But for residential condominium buildings, it looks like it will not. And that's pursuant to a news release from the City of Toronto, and also from reading the text of the bylaw itself and its definition of what is an establishment. So when we look at the text of the bylaw and we look at the interpretation, what they're really talking about is mandatory masks in enclosed commercial settings, and the other type of public setting would be governmental. But it does not apply to residential. So now that you know that you don't have to have a mandatory mask policy, the next question that you would turn your mind to is whether you should, and what might that policy look like, and how would it be enforced, and by whom. And these questions will depend on your particular condominium community and where you're located. So something I'll mention also before we get into individual condominiums is that this is not just going to be for the City of Toronto. It looks like similar emergency orders or municipal council bylaws are going to be implemented in lots of different parts of Ontario, including York Region, Peel Region. You might see it in Durham, we're not sure yet. You're likely to see it in the Windsor area, in the Guelph, Dufferin area. All of these different municipal areas have come forward and said that they are either doing it now, Kingston has already done it. And so there's lots of places in Ontario where these bylaws are being enacted, and if you're not sure with respect to the location of your particular condominium corporation, you can let us know and we'll be happy to look it up for you. And of course, this information is going to be changing rapidly over the next couple weeks as these types of policies get adopted across the province. So turning back to individual condominium corporations, and specifically residential condominiums, where it is not required to wear masks, what should condominium corporations be doing? Some condos we know have already implemented things like health questionnaires and mask policies. In our view, that's fine. But what happens if someone's not wearing a mask and they live in the building and they're coming in? Are you going to stop them from entering the building in their own home? How would this be enforced? It's a very difficult question, whether you can actually stop someone from entering the building. And I would suggest that enforcement is not through stopping people, right? That enforcement should not mean physically preventing someone who lives in the building from entering the building simply because they're not wearing a mask. That's not the proper enforcement. The proper enforcement is to ask them to please put on a mask, and if they refuse, then you would follow that up with a compliance letter from the manager, or if necessary, a compliance letter from the condominium corporation's lawyer. We don't want people getting into physical altercations over wearing of masks, and we don't want we don't want that kind of conflict in condominium communities. It's counterproductive to the point of physical distancing and safety. So enforcement is really the tricky issue, and deciding what's best for your condominium. It's going to depend if you have a security guard. It's going to depend on the layout of your property, whether physical distancing is possible, how many people live in your condominium community, all of these things. And not everyone's going to come up with the same answers, and that's okay. That's part of the nature of condominiums, that there are different communities and they make different rules and policies that suit your particular community. So these are things that we're going to be talking about a lot with our clients over the next few weeks, we expect. And we know that some of those requests started coming in right away, and we're dealing with them all as soon as they come in. We treat them urgently. So are there any other questions from you? We've talked about masks. We've answered your questions about boards and real estate showings. We're looking in the news that stage 3 might be coming, and what will that mean? So we're going to start talking about that in the next coming weeks, and what that means for condominium corporations. And the other thing that's come up a lot, and that I'll mention now, is the concept of waivers for amenities. So a lot of condominium corporations are asking us for waivers. We think they're a good idea. They have to be properly written. They have to be tailored to your community. And once again, there's no one size fits all for these types of things. They have to be customized to what makes sense for your condominium corporation. So we would encourage condominiums that are taking waivers from other communities and just changing the name on them and sticking them out for themselves. Don't do that. Please get someone to look at them and make sure that they're appropriate. Just because someone else is using it doesn't mean it's the right thing for your condo. And the other thing that we're doing is we're going through condominiums that have a lot of amenities, and we're helping the manager figure out, depending on the location of your condominium and depending on what kind of amenities you have, what is allowed to be reopened now and what must stay closed. Because it's going to depend, because every condominium has slightly different amenities, and it's also going to depend on the size of them and their capacity and the ability to provide physical distancing. So we'll see if we can take a couple more questions. Today doesn't have to be a very long live stream. We know a lot of people are on vacation, and so it's okay if it's short. And then if people still have questions and haven't had an opportunity to ask them, they can reach out to us via email, and that's great too. So take a question here from Michelle again. Is the City of Toronto supposed to make another announcement on masks in regards to residential condos? I'm not sure if they're going to make another announcement with respect to residential condos. Obviously, I'll be really interested if they do to see what they say. But the big thinking on this, at least for now, from my perspective, is that a residential condominium building is not open to the public in the same way that a commercial establishment is. So any person off the street can walk into a commercial establishment and expect to be permitted entry. And the same is not true of a residential condominium. It's really restricted in terms of entry to the people who live there and their guests and family members. And so it's very different. It's not really a public space. It's a shared space, but it's private. It's privately owned and it's controlled. So the same would be true in offices that are not open to the public. So for example, even though I work in an office, in case you didn't notice, I'm not in my son's bedroom anymore. I'm back at the office because we have our kids in camp. Even though I work in an office, my office is not open to the public. Our door is locked and you can't just come in. You have to have an appointment. And so because of that, the mandatory mask bylaw in the City of Toronto does not require me to wear a mask while I'm at work. But if I was in an environment that was open to the public where anyone could come in, then I would have to be wearing a mask. So it's a little bit tricky. Okay, question from property manager. Once emergency orders come to an end, what are the expectations for virtual AGMs for those corps without a bylaw? That's a really great question. So in the there is a temporary amendment to the Condominium Act that talks about virtual meetings and applies until the state of emergency comes to an end. We don't know when that will be, but it says with respect to electronic meetings for those condominium corporations that don't have a bylaw, the emergency provisions continue for another 120 days. So if you were planning to have a virtual AGM and then before your meeting is held, the state of emergency ends, you can still go ahead with your virtual AGM, at least this year. And then if you wanted to continue doing virtual meetings in the future, you would need a electronic meetings bylaw. And so for that reason, we are saying to people, if you think that electronic meetings is a thing that people are going to want in the future, even if it's just like combined so that there will be in-person and electronic, people will have the choice, then this is something you should do now. Because right now you can pass it electronically, and if you wait and you don't pass it in an electronic meeting, then you would have to have an in-person meeting in order to pass it, and that extra step could be problematic for you. So to avoid that, we say now is the time to do your electronic meeting bylaw. If you're going to have an electronic AGM at the same time, it's good to throw in the passage of an electronic meetings bylaw that allows you to continue to do it in the future, because we do not know what the future will hold and for how long these types of limitations on in-person gatherings might be in place. So Michelle is asking me about how about tradespeople coming in and doing work in the condominium building. I would say that it is a very, very good idea for condominium corporations to have a policy in place that says that any tradesperson coming into the building to do work should wear a mask. I think that's a pretty standard practice right now. Most tradespeople are doing that anyways, and it's something that condominium corporations can, in my view, require. The more difficult issue is what do you do about residents and guests, but for tradespeople, I think it's pretty clear that you would require them to wear masks, and you would just do that by the board, passing a resolution and notifying, putting up signage and notifying owners. And I don't think it's something that you would have to do necessarily by way of a formal rule. So I hope that answers your question about tradespeople. We'll see. I don't know if there's any more questions. It's been a bit of a interesting week because of the holiday. So I don't know if a lot of our usual suspects for questions are there. Oh, so Michelle's saying not all trades wear masks. Delivery people and even the mailman does not. So I would say, Michelle, that you should strongly consider having some signage at the entrance indicating to delivery people, trades, and mail carriers that it is expected that they put on a mask before they enter your indoor common areas. And I would say that it should be strongly suggested that your residents wear them, but I wouldn't go so far as to make it mandatory unless there's widespread consensus in your community that this is the right thing to do. So I think you should talk to your board and talk to your residents about whether there is consensus on this point. And I think if you find that there is consensus that people think masks should be mandatory, you can let people know that that's the policy of the corporation, to wear masks in indoor common areas where physical distancing is not possible. And you would have other, similar provisions about elevators and how any amenities can be used. And you would create a comprehensive policy that applies to all people and all parts of your building, taking into consideration the specific circumstances of your condominium. So yeah, Michelle. Leo, the corp has an HRTO claim and the insurer of the corporation has assigned a solicitor to defend the corp, but he is not an HR specialist. Can the corp request an HR specialist to defend the case? So HR, I'm assuming you means human rights and not like human resources. Okay, so this has to do with insurance. So let's talk about it. Condominium corporations typically, but not always, have insurance that covers the cost of a legal defense when you are sued in the Human Rights Tribunal of Ontario. And different condominiums have different policies, but typically that cost is they'll cover up to $100,000. And often it is a condition of the policy that you use a lawyer who is satisfactory to your insurer, and your insurer may have a contract with various lawyers saying that they will only use lawyers who are on their roster, and in return the lawyers agree to give lower hourly rates to the insurance company. So it's a mutually beneficial agreement. So what I would suggest you do is talk to your insurer and ask, if you're not happy with the lawyer who they've appointed, if you can change to, and if they can provide you with a list of all of your available options. And then you can actually call those lawyers and interview them and pick a lawyer of your choosing. And that should be fine, to pick from among the roster of lawyers that they have, whoever you like the best. And if you're not happy with any of them, then you can talk to your insurer about whether they can let you pick your own lawyer. And so long as that lawyer agrees to your insurer's prescribed roster rates. And so this is a conversation that you should have with your insurance company about finding the lawyer who's the best fit for you. And if you're totally dissatisfied, you still have the option to hire your own lawyer at your own cost. So it just has to depend on the terms of your insurance. And when you purchase insurance, it's a contract, and it might say that your insurer has the right to pick a lawyer for you. But of course, the most important thing is that you're happy with the lawyer and that you're getting the service you need. So if you're not happy, you can make a change, and you should talk to your insurer about it. And if you're having difficulty with your insurer, you can talk to your condominium lawyer about it, and they can help you get the right lawyer for your case covered by your insurance. So this is definitely a solvable problem, Leo, and you should speak up and do something about it. Carrie, when the contact tracing app becomes available, so this is something that the province of Ontario is currently working on. They had a little setback, but they're hoping to make it available. Can a board compel visitors to use it? What about residents? That's a really interesting point, Carrie. I've never thought about it. So how would you know? How would you know if they are? I don't know. The app doesn't exist yet, so we don't know a lot about it. One of the essential components of this app is that it is supposed to be totally voluntary. So I think you should keep that in mind. And the reason why it's supposed to be totally voluntary is because people have concerns about privacy and the fact that the app really does trace where you go and record a lot of information about you. So in that respect, I'm not sure that a board would be able to legally compel someone to use it. And I'm not sure if you'd be able to know if they do or they don't. But something you could definitely do is require visitors to sign in. And that is very much the equivalent of contact tracing. It's also something that you should do if you are opening amenities, is that anyone who goes into, if you have a swimming pool or when gyms reopen, you have sign-in sheets, and that is used for contact tracing purposes. I think if you're not going to use the app, maybe we do it the old way and you just have people sign in when they come into the building and sign out when they leave, so that if there is a exposure, they can be contacted. And that might be the sort of low-tech, simple solution to your problem. Okay, let's see if we've got a couple more questions for today's sort of abbreviated live stream. And if we don't, then we'll call it for today, and we'll see you all next Wednesday. So we postponed it a day because of Canada Day. So I don't see any more questions coming in. We talked about board members, we talked about masks, we talked about waivers, we talked about contact tracing, we talked about reopening amenities, and all of these things are high on at the front of people's minds right now, and that's okay. And there was a period of time where it looked like we had sort of settled into a groove of knowing what was going on, and then all of this stuff about masks happens, and reopening, and stage 2 and stage 3, and now we're all busily getting caught up again in terms of the rapid development of the law. Okay, we'll do last question here from Michelle. She asks, are we responsible for contact tracing for each and every amenity we open, like the library, party room, card room? I would not say that you are legally responsible, but I believe that you have a moral responsibility, and it would be good management practice to have sign-in sheets or reservation sheets for every amenity that you open. So if you are going to have, library, party room, card room, people should be either reserving a time when they're going to use it, which avoids overcrowding, or at the very minimum signing in and out. And that asking people to do that and having those sign-in sheets available for people is should be an essential part of your safety plan for your building, so that if you get a COVID positive confirmed case and that person was using the amenities, you can easily contact all of the people who were there at the same time using your sign-in sheets, and it could make a big difference in terms of containing what would otherwise be a very bad outbreak in your building, which is something you don't want. So Harland, last question, Harland. Is the condominium corp required to hire a security guard to enforce 2-meter distancing and cleaners to clean the amenity regularly? Will a properly worded waiver protect us if somebody comes down with COVID? I would not say that it is the job of your security staff to enforce 2-meter distancing. I think it would be sufficient, in my view, to have appropriate signage. And I think with respect to cleaners, I would be directing the cleaners to more frequently clean what are known as high-touch surfaces, so things that people frequently put their hands on. So it would be more about redirecting your existing cleaning resources towards those areas that are the most important. And I think that you might have to spend a little bit more on cleaning, but that would be sufficient. So these are common sense things. And then will a properly worded waiver protect us if somebody comes down with COVID? It could, but you have to make sure that people sign the waivers. And so that is also a factor to consider. And I would say something like if you're going to be, reopening the gym, that having someone fill out a questionnaire confirming that they don't have symptoms and acknowledging the risks of COVID and waiving liability would be appropriate for people to use something like a gym where there is a reasonably high chance of touching equipment that other people have touched, which carries with it an inherent risk of infection. That people recognize that they've been warned about it, and therefore, because you've taken the step to warn them in the waiver, you have actually satisfied your legal obligation as the occupier. So these are things that you should be doing, and I think that they make sense for your particular condominium, Harland. Property manager, could we not use a key fob log for contact tracing for amenity use if that exists? You could, except the key fob only tells you which fob. It doesn't tell you exactly who, but that's a pretty good solution, I think. If you were going to go with a key fob instead of having a sign in or a sign out sheet. It also wouldn't help you if someone like held the door open for somebody else. So probably the best thing to do would be to keep a sign in sheet and use the key fob as a backup, not rely on it exclusively. Yelena, we are 2 buildings with shared amenities. Building A wants a waiver for amenities. Building B doesn't. Can Building A protect itself by having a waiver? So Building A would have a waiver for its own residents, basically, and Building B would not. These are things that happen, and it's obviously better, Yelena, if the Shared Facilities Committee can sort of reach a decision on this. Because the shared amenities should be, and any rules with respect to using them should be something that the Shared Facilities Committee deals with. So I would say at first instance, it's a Shared Facilities Committee decision whether you're going to have a waiver for your shared facilities. And then if, let's say the Shared Facilities says that they don't have the votes to make it mandatory, then Building A is going to do their own waiver, and they're going to say in it whatever they're going to say with respect to their own building and their own residents, and I think that's their prerogative. So I don't have a huge problem with it. But try to get the Shared Facilities Committee to agree, because that's the better way to do it. Okay, everyone. We got started a little late, and for which I apologize. We had a little internet issue there, but we got to some really great questions today. It's 12:45. Question just popped up here. As with the pool, we will be receiving direct clearance for other. As with the pool, will we be receiving direct clearance for other indoor amenity reopening? Okay. This question. Okay. So I hope you're looking at our weekly FAQs. We try really hard to give guidance on what amenities can be opened and what has to stay closed at each interval of time. I think things like gymnasiums, you might expect to get a specific direction in the form of an emergency order from the government, but things like party rooms and card rooms, we're going to have to sort of read between the lines of the existing regulations to figure out what's allowed and what's not, and that's something that we're doing as condominium lawyers, and other condominium law firms are also doing. So we're going to try and make sure that you as managers have that information as quickly as possible. And that's why we will continue to publish our weekly FAQs, and where we will update people once a week on the status of things like what amenities can be opened across Ontario, and where there are different rules in different parts of Ontario, what those different rules say. So we're keeping on top of this for you, and that's the purpose of the FAQ. And we hope that you find that useful, even though it's a lot of the same information every week. There are changes, and so it's there for you when you need it, and we're happy to keep doing it. So thanks, everyone. We will see you next Wednesday, and we will look for our FAQ on Monday. And Tuesday, July 7th, mandatory masks in enclosed public spaces, City of Toronto. Crazy stuff. See you next week.